Edward Snowden just leaked this about Ripple XRP holders. Is it possible to relist XRP on Coinbase? What will such an event lead to? We will answer these questions in today's video. The current price of XRP for today is $0.35 and the trading volume for 24 hours is $136,000,000 We are updating our XRP price in US dollars in real time. XRP has dropped 30% in the last 24 hours. Welcome to the Rich Club channel. If you like this video, don't forget to like it and subscribe to the channel. Do you think the analysts are right about XRP? Write the answers in the comments. Giving away 500 XRP at the end of the week. One random subscriber will receive XRP coins. Take a look at the instructions in the comments section. All you need to do is write the word XRP, watch the video to the end to like and subscribe. The Relative Strength Index, RSI, has not been definitive over the past few days. Last week, the RSI held a neutral value of 50 as support, but recently this level has not passed. Thus, there may be some volatile dynamics during the weekend. Similarly, the Awesome Oscillator, AO, was also below zero. He has not yet shown a strong bearish impulse. The A/D line had a resistance zone that was directly overhead and was indicated by two dotted white lines. If A/D can overcome this region, it will be a sign of sustained demand for the XRP rally. The Directional Movement Index, DMI, showed the absence of a strong trend. ADX, yellow, it was at level 20, ADI just above the 20 mark. Technically, this indicated a bearish trend, but in general meant the absence of a significant trend over the past few days. The $0.35-$0.36 range will be important to protect the bulls over the next day or two. The formation of a lower low below this area will signal bearish strength. Momentum indicators were inconclusive on the lower timeframes. Bitcoin could also strongly influence the direction of XRP in the near future. The Securities and Exchange Commission responded to a request from Ripple and individual defendants to serve subpoenas to two non-parties to authenticate 7 videos of public speeches by SEC officials. The SEC described Ripple's request as a reopening to resume the pretrial stage of the study, adding that it does not take any position on the defendants' claims. Recall that on August 3, 2022, Ripple requested permission to serve subpoenas to two video hosting platforms to obtain 7 videos of commission officials on which they made various public statements. After waiting 5 days, the Commission filed a brief response to the defendant's request, which reads, "The plaintiff, the Securities and Exchange Commission respectfully takes no position with respect to the defendant's request to reopen the investigation of the facts in order to file subpoenas to third parties in order to obtain video recordings for authentication." Hashtags or community, hashtag #SecOfVersus. Hashtag Ripple, hashtag XRP. The Securities and Exchange Commission has filed a one-line response to Ripple defendants' efforts to enforce Judge Netburn's decision to authenticate SEC officials' videos. The Securities and Exchange Commission said it was not taking a position on Ripple's request to resume fact-finding. SEC plans to change Ripple's request in its favor. Notably, Ripple has stated that its request is not an attempt to reopen the discovery of facts. The blockchain company and 2 of its executives noted that the subpoenas they want to serve to a person who is not a party are related to requests for admission, RFA, filed before the end of the discovery. It's clear that the SEC wants to mark Ripple's request as a fact discovery rediscovery because it also wants to resume fact discovery. The Commission also plans to serve its subpoenas to obtain unidentified video recordings, which confirms its claim that XRP is a security. In particular, the Securities and Exchange Commission informed the defendants that it would consent only if the defendants agreed to reopen the investigation so that the Securities and Exchange Commission could now serve its own set of subpoenas to obtain copies of unspecified videos in support of its claims, and only if the defendants also agree. Waive any objections regarding authenticity and procedural objections to unknown SEC videos, Ripple said. However, Ripple maintains that its request is not to reopen the discovery of facts, adding that it strongly objects to the SEC's attempts to do the same. The blockchain company stated that the subpoenas that Ripple intends to serve do not pose a problem for the court schedule. Commenting on this event, lawyer James K. Phelan, a former U.S. federal prosecutor, criticized the response of the Securities and Exchange Commission as an abuse of the judicial process and a waste of court time. The SEC's response is simply an abuse of the judicial process and a waste of the court's time, as evidenced by the fact that the SEC waited 5 days to file a one-sentence response in which the SEC misinterpreted Ripple's original request. The parties want their petition to be classified. Meanwhile, both the SEC and Ripple have jointly filed a request for a briefing scheduled for the proposals to seal parts of their response to each other's proposal in order to exclude expert testimony. The parties propose that all briefings and supporting documents concerning petitions to exclude expert testimony should be classified until Judge Analisa Torres deals with this. Hashtags or community, hashtag #SecOfVersus. Hashtag Ripple hashtag XRP. The parties have submitted a request for a briefing schedule for proposals to close parts of their responses to each other's proposals in order to exclude expert testimony. This means that everything will be recorded and will remain sealed until Judge Torres has sorted it out. Ripple and individual defendants Brad Garlinghouse and Chris Larson have filed their responses to the U.S. Securities and Exchange Commission (SEC) objection to Judge Sarah Netburn's decision on William Hinman's documents. Recall that initially the SEC claimed that it could not hand over drafts of Hinman's speech because the documents are protected by the privilege of the deliberative process, DPP. Judge Netburn rejected this argument. After the court's decision, the SEC also filed another motion, arguing that Hinman's documents are protected by attorney-client privilege. The Securities and Exchange Commission claimed that Hinman had received legal advice from the commission's lawyers before drafting the speech. That motion was also rejected by Judge Netburn, who later criticized the SEC for its hypocritical tactics. As a result, Judge Netburn has already ordered these documents to be provided 3 times. Despite these rulings, the SEC still objects to the order, but to Judge Torres. According to the Commission, the court made a mistake in its decision. According to Ripple, the SEC wrongfully objects to the decision because it cannot show obvious errors in any of the decisions. The SEC actually acknowledges that Judge Netburn correctly understood the law on these issues by outlining the legal tests in almost identical terms and referring to the same authority. He disagrees only with the actual conclusions of the court and the natural conclusions from them, reads an excerpt from Ripple's response. Regarding Judge Netburn's decision on the SEC DPP's claims regarding Hinman's documents, Ripple stated that the verdict complies with the generally accepted law of the Second Circuit as applied to the record created by the SEC. The blockchain company and its executives also noted that Judge Netburn's decision on the SEC's claims regarding Hinman's documents corresponds to the direct application of the indisputable law to the actual records and affidavits submitted by both Hinman and the agency. In addition, Ripple criticized the SEC for changing what was said earlier, as it considered it appropriate to prevent the transfer of drafts to the company. It is noteworthy that the SEC claimed that Hinman's speech in 2018 was his personal opinion and did not reflect any of its policies. However, a year later, the SEC made a U-turn, saying that the speech was a guide for market participants. The SEC sought to put the toothpaste back in the tube and rely on contradictory arguments from lawyers to avoid the consequences of its judicial strategy. But this was not a mistake, it was the correct application of the law to the facts. The SEC's objection should be rejected, Ripple said. Meanwhile, attorney James K. Phelan noted that Ripple and the Securities and Exchange Commission have begun filing petitions to exclude expert testimony. However, petitions are filed in closed form until Judge Analisa Torres decides what should be made public in the documents. Hashtag Zer Community, hashtag Seca versus. Hashtag Ripple, hashtag XRP. The parties submit their responses to petitions to exclude expert testimony. Everything is sealed now, so there's nothing to see, but those of you who follow the registration services will receive notifications that the cases are on the list. Now it is time to reveal who is the lucky winner of our giveaway. We randomly selected one fan who fulfilled all the conditions. And the winner is Ava Hull. Congratulations, Ava Hull. So XRP Army, let's all congratulate Ava Hull in the comment section below, and tomorrow we will relaunch our weekly giveaway free 500 XRP. Now let's get back to the video. What do you think are the prospects for XRP in 2023? Write your forecasts in the comments. Thank you for watching this video to the end. Please do not forget to like it and subscribe to the channel so as not to miss the release of new videos, and do not forget about our contest. Write in the XRP comments to add 500 XRP to your account.